Section 8 of A History of the Inquisition of Spain, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. A History of the Inquisition of Spain, Volume 3, by Henry Charles LEA. Book 6, Chapter 8, Part 3. We have seen that, after the accusation was read and answered, the prisoner was told to choose an advocate. Possibly two names were mentioned to him, both equally unknown, more often only a single name. He was not at liberty to refuse, and on his giving assent, the advocate, who had been kept in readiness in the antechamber, was called in. The proceedings up to that point were read to him, and he at once performed the duty of urging his client to confess. Whether successful or not in this, he stated that the next thing in order was to conclude. The fiscal was called in, who similarly announced that he concluded, and the inquisitors notified both parties of the conclusion. These formalities being over, the case was formally received to proof. The fiscal asked that his witnesses be ratified and publication of evidence be made. Ratification, as we have seen, frequently caused considerable delay, until the device was invented of ratifying at the time of deposition. When the evidence was thus in proper shape, the next move was its so-called publication. This might or might not be the final step of the prosecution, for it never was precluded from bringing in new evidence, and there might be half a dozen or more successive publications, especially when a group of Judaizers were on trial and they broke down one by one and told what they knew about their associates. The effectiveness of this is illustrated by the case of Engracia Rodriguez at Valladolid in 1643. After her case had apparently reached its end, the consulta de fe voted her to torture, which was duly administered without eliciting a confession. Then from time to time came new publications of evidence, until her resolution gave way and, at the seventh publication, 11 months after her torture, she confessed to Judaism. She probably recognized that her kindred and friends were yielding, one after another, and incriminating her, and that it was useless to resist longer, with the certainty, of which her advocate doubtless informed her, that persistence would indubitably end in her burning alive as an impenitent negativa. As this publication of evidence was the only inkling afforded to the accused of what was the case against him, and as it was assumed to give him ample opportunity of defence, it is worth a little special consideration. We have seen that the pretext of protecting witnesses was held as justifying the suppression of their names and of all circumstances that might lead to their identification. Even under the most rigid construction, this crippled greatly the defence, but rigid construction of their powers was not common among the tribunals. When once it was admitted that portions of the evidence could lawfully be suppressed, the selection of what should be made known became largely discretional. The endeavor to lay down rules for guidance as to this led to an infinity of instructions, more or less rigid or lax. In 1498, the Suprema called attention to the evils that had hitherto followed publication, wherefore in future care must be taken to omit all circumstances giving a clue to the identity of the witnesses, and this was repeated in 1499. Yet the glaring injustice of withholding from the accused a knowledge of details that might enable him to disprove the charges was recognized, but all instructions forbidding this were framed with an "if" that virtually authorized the wrong. For instance, the specification of time and place at which an act was said to have been performed was indispensable if the accused were to have a chance of detecting false swearing, yet such details might possibly lead him to identify the witness, and these opposing reasons gave rise to a series of varying orders which indicate how the Suprema vacillated between the desire to secure the advantage and the consciousness of the wrong. In 1525 it condemned the practice of the Toledo tribunal in omitting time and place. It was difficult to make the inquisitors observe this and, in 1527, a general order was issued to state the evidence as the witnesses had given it, neither more nor less. In 1530 it made a concession by ordering that it should be consulted when there was inconvenience in stating the month or year. Then, in 1532, it laid down the positive rule that place and time and persons must be stated, for the principle that the witness must be protected was to be construed as preventing only direct recognition and not inferential. This was again modified in 1537 when, while again ordering that all the evidence must be given, this was qualified by the old injunction to suppress all circumstances by which the witnesses could be identified. About 1560, some instructions to Barcelona ordered that the time should be stated, while place is to be indicated in such general terms as shall not betray the witness. Finally, in the definitive instructions of 1561, time and place are ordered to be given, but at the same the omission is prescribed of all that may betray the witness. A caution that no evidence is to be used that is not in the publication gives a hint of other irregularities of even a more serious nature. The publication being a matter of supreme importance, it was the duty of the inquisitors personally to draw it up, and not entrust it to subordinates, least of all to the fiscal, who was technically the prosecutor. Orders to this effect were issued in 1529. They were repeated in the instructions of 1561, but, in 1568, the Suprema was obliged to take the Barcelona tribunal to task for allowing the fiscal to do it, and a later writer informs us that inquisitors continued to shirk the labor and threw it upon the secretaries. The labor was doubtless great, when the witnesses were numerous and loquacious, and the delicate duty was apt to be recklessly performed by subordinates, fearful of rebuke if they allowed too much to be known. The custom was to give the evidence of each witness separately, as deposed by a certain person, and, when practicable, to divide it up into articles, each covering a separate charge or fact. In this process the elimination of all circumstances that might give a clue to the identity of the witnesses was easy, and there was little scruple in misleading the defendant or in omitting whatever might be thought to weaken the case. In the publication read to Marie Gomez Lasazeda, when on trial at Toledo in 1544, the evidence of one witness is divided and represented as given by two, with the object, as noted on the margin, of preventing her from identifying him. In the case of Gaspar de Torralva, before the same tribunal in 1531, the publication bears such notes as "the evidence of the seventh witness omitted," "the evidence of the eighth witness omitted. There was no possible supervision or control over this. The discretion of the inquisitors was absolute, and the prisoner was at their mercy. In many cases the publication was scarce more than a slovenly repetition of the fiscal's accusation and afforded to the accused no possible aid in his defence, as in that given to Juan de la Barra, tried for Lutheranism at Toledo in 1656. When it was drawn up more elaborately, it became confusing in the highest degree. One reads the long array of the assertions or the conjectures or the gossip retailed by 25 or 30 witnesses, vaguely set forth as what a certain person said or thought about another certain person, with no specifications of time or place, and one wonders how the prisoner could even grasp it sufficiently to form any definite conception of the character and weight of the evidence against him. And, with his life perhaps hanging in the balance, he was required to answer all this on the spot, article by article, and was closely cross-examined on his replies. That even an innocent man should compromise himself in the pitfalls thus cunningly laid for him was not unlikely, and yet this publication of evidence was represented as a special favour granted in view of the other restrictions imposed on the defence, a favour not always conceded in the secular courts. After this ordeal was passed, the advocate was called in and furnished with the publication and the answers of the accused. The two conferred together, under the eye of the inquisitor and pen of the secretary. If the accused rejected the renewed advice of the advocate to confess and discharge his conscience, the plan of defence was concerted. What this was, as a rule, made little difference. When in 1499 the inquisitors general felt it necessary to instruct inquisitors that they must pay attention to the defences and exceptions alleged by the accused, it indicates how they were recognized as prosecutors rather than judges. Yet it was freely admitted that, in view of the limitations of the defence, they should be most zealous in considering whatever it presented. The defence was so perfunctory a routine that the systematic writers mostly dismiss it with the curt observation that its witnesses must be zealous Christians and in no way connected with the defendant. Simancas, however, treats it at greater length, and his enumeration of its possibilities shows how restricted they were. He admits at the start the legal maxim that it is impossible to prove a negative, which was virtually, in most cases, the task imposed on the accused. Then he proceeds to define what the defendant can do. He can call on witnesses to prove his religious character, or to disable for enmity the opposing witnesses, or to show that at a certain time or place he did not say what was attributed to him. Then there are general pleas in abatement, extreme youth, second childishness, insanity, drunkenness, thoughtless speech, ignorance, jocularity, the pressure of fear under threats, or intense grief. Or he may recuse the judge, which should be referred to the Suprema and not to arbiters who cause much delay. Recusation of a judge was a right recognized in the traditional legislation of Spain. It was admitted in the Inquisition, and we have seen, in the cases of Carranza and Villanueva, how little the accused profited thereby, even when nominally successful. It was a recourse practically open only to the powerful or to the trained, at best but a dangerous expedient, and of necessity had to be done at the commencement of a trial. It evidently was not employed often enough for a definite form of procedure to have been provided. The Instructions of 1561 require that, if an inquisitor be recused, he must abandon the case to his colleague. If he has none, or if both are recused, the matter must await the decision of the Suprema. This would indicate that the recused judge retired as a matter of course, but the Carranza and Villanueva cases prove that the objections of the prisoner had to be demonstrated as legitimate, and this is further indicated when the troublesome Jesuit, Padre Juan Bautista Poza's extravagant Mariolatry was condemned at Rome and approved in Spain. It took 7 years after his Elucidarium Dei Parai had been placed on the Roman Index in 1628 before the Spanish Inquisition could be compelled by the nuncio to prosecute him for his rebellious defiance. When on trial by the Toledo tribunal, he recused the Inquisitor Cienfuegos. His reasons were examined by the Suprema, which consulted the other inquisitors, and the recusation was sustained. How unusual was this proceeding is indicated by the boast of his triumphant brethren that this was one of the remarkable events that had occurred in Spain. Yet an incident in the trial of Fray Luis de Leon shows the advantage taken of any obstacle to prevent recusation. After 2½ years of seclusion in prison from the world, he asked to know the names of the existing Inquisitor General and members of the Suprema, in order that he might recuse any whom he regarded as inimical. Yet this elementary piece of information was denied, in spite of repeated applications, in which his counsel joined, showing that the latter was debarred from telling him what was of public notoriety. Strictly speaking, recusation was not a defence but merely a preliminary to it, and its rarity renders it of minor importance. Of the pleas in abatement enumerated by Simancas, that of youth amounted to little for, as we have seen, as soon as the age of responsibility was reached, the offender was liable to punishment and there was little mercy shown. In fact, there was a device, when the culprit was below the age of 14, of postponing the sentence until he had attained that age. Insanity was of much greater moment. The insane were recognized as irresponsible and were sent to hospitals. It was not infrequently pleaded, and the tribunals were constantly on the watch to protect themselves against deception, yet it was long before definite rules were adopted with regard to the matter. In the enlightened view taken by the Inquisition regarding witchcraft, Instructions of 1537 indicate a disposition to regard reputed witches as insane. Whenever the inquisitors considered this to be the case, all acts and words leading to such conclusion were to be scrupulously detailed in the records. Barcelona at the time had on hand a witch named Juana Rosquels, whom the physician and consultors considered to be out of her mind. Not knowing what to do, they referred to the Suprema, which ordered her discharge and somewhat inconsistently required her to be put under bail. Even more tentative was the case of Toledo in 1541 of Juan Garcia, a day laborer, favored with revelations of the wildest kind. In his audiences he replied unintelligibly to the questions asked and, when the case came before the consulta de fe, it summoned him and asked whether he would take 100 lashes or confinement in a hospital. He very sensibly declined both, and the session terminated with a vote that his sanity be investigated. This was done in the most superficial way. The consulta de fe, when reassembled, voted to acquit him, with the warning that if he persisted in his wild talk he should have 100 lashes, whether insane or not. He was accordingly told to be gone in God's name. There evidently was as yet no method prescribed for dealing with such cases, and it is somewhat remarkable that the Instructions of 1561 allude only to those, by no means infrequent, in which prisoners became demented during trial, and in this it is only ordered that they be provided with a curador, which infers that the trial was to be continued. In conformity with this, at Granada, in 1665, a prisoner who had become insane after confessing was furnished with a curador, under whose auspices the case was carried to conclusion. He was condemned as a heretic and his property was confiscated. As he had confessed and begged for mercy while still in his senses, he was absolved from censures so that he might enjoy the suffrages of the Church, while as to the penances requiring sanity for their performance, such as reconciliation, abjuration, exile, etc., their determination was postponed till he should regain his reason. When madness occurred after conviction and sentence, Peña tells us that the execution should be postponed until the reason is restored, for perhaps the culprit may repent and he is sufficiently punished by the madness. Even when it is feigned, this should be done, for it is a less evil that the crime should be unpunished than to destroy his soul by putting him to death impenitent. In any event, confiscation is to be enforced. When the accused was decided to be insane, the plan adopted was to transfer him to a hospital, but in 1570 the Suprema required to be consulted before this was done. Hospitals were not always willing to receive such patients, but they were constrained to do so, as appears by an order of the Suprema in 1574 in such a case. The diagnosis of insanity is sufficiently obscure to modern science, and it is not surprising that the Inquisition experienced difficulty in protecting itself against attempts at imposition, which were regarded as frequent. Peña informs us that insanity was always looked upon with suspicion, as probably fictitious, but he can only suggest that the jailers should keep careful watch and the inquisitors threaten or employ torture, to which there was no objection, unless there was risk of death, and which was an effective means of detecting imposture. There was, in fact, as we have seen, no hesitation in having recourse to it when other means failed, but it is to the credit of the Inquisition that it was ready to exhaust all its resources in doubtful cases to determine the question of sanity, however much its ultimate conclusions might be warped by prejudice or preconceptions. An exceedingly illustrative case was that of Benito Ferrer, a wandering beggar, wearing priestly garments, arrested in Madrid, August 24, 1621, by the archiepiscopal police and confined in the spiritual prison. He was about to be discharged when, on September 20th, while mass was being celebrated in the oratory, he sprang forward at the elevation of the Host, snatched it from the hands of the celebrant, crushed it and cast part of it on the floor, exclaiming, "O traitor God, now you shall pay me!" The sacrilege, of course, caused the greatest excitement and indignation. The archiepiscopal court took cognizance of the matter and was about to discharge Benito as crazy, when the Inquisition claimed him and sent him to Toledo for trial, with orders to push the case. Before leaving Madrid he was examined by the commissioner, when he asserted his entire sanity, and explained his act by asserting that the Host was not consecrated, for the priest and everyone else whom he saw were enchanted demons. Benito was undoubtedly a monomaniac, for in his subsequent audiences he stated that, in 1609, he had been bewitched, since when everyone he met was a demon, with much other wild talk. His advocate asked for an investigation into his sanity, which was performed somewhat perfunctorily, with the result that his extravagance was pronounced to be feigned. Still the consulta de fe, on November 23rd, voted in discordia, and the Suprema ordered further examination into his record and antecedents. 20 years before, in his native Catalonia, he had endeavored to enter religion. 2 convents had refused to receive him, and 2 others had expelled him after a few months. The tribunals of Valencia and Barcelona were set to work on these faint traces. The friars of that time were dead or scattered, but after 6 months of search 2 or 3 were found who vaguely remembered him as a melancholy person of little sense, who seemed to be possessed. Then followed further examinations of fellow prisoners and physicians, concurring in the belief that his insanity was a fiction, and fruitless efforts were made to induce him to admit it. Another consulta de fe, held September 10, 1622, voted unanimously for relaxation, but the Suprema was not yet satisfied, and ordered torture as a last resort. When the sentence was read to him, he simply said that he was ready for what the Divine Majesty might be pleased to do with him. Then for 3 hours he was exposed to the extremity of torment, the blood dripping to the floor from his lacerated flesh, but, amid his shrieks and groans, nothing more could be extracted from him than "God suffered more, I am here to serve His pleasure," and an offer that, if they would give him a Bible, he would prove them all to be demons. If torture meant anything as a test, this proved his insanity to be real, but 2 days later a consulta de fe unanimously voted his relaxation as an impenitente negativo. Still the Suprema was not satisfied. It thought that the torture had been insufficient, and it ordered him to be confined with persons of confidence who should keep strict watch over him. Accordingly, on November 23rd, his cell was changed and he was given as companions 2 friars and a physician awaiting trial, duly sworn and instructed. February 8, 1623, they were examined and pronounced him sane. But Dr. Antonio Gomez, who examined him, thought him liable to delusions. Many persons, he said, were sane in everything but one topic, on which they were insane. Still the Suprema hesitated and ordered continued observations, which were prolonged until November 4th, with the same result, when another consulta de fe unanimously voted for relaxation. the Suprema could hold out no longer against these repeated convictions. It confirmed the sentence and he was burnt alive as an impenitent, January 21, 1624. Erroneous as the conclusion may seem to us, it was not reached without a prolonged and conscientious investigation, such as no other tribunal of the period would have given to such a case, though the archiepiscopal authorities were wiser when they promptly recognized Benito's madness. A nymphomaniac in 1688 caused the Valencia tribunal an even longer term of perplexity. Francisca Garcia was arrested March 28th as an alumbrada, one of the mystics against whom the Inquisition waged unrelenting warfare. She frankly admitted her sexual excesses, which she said were in obedience to the voice of God. During audiences at long intervals, her talk was so irrational that insanity was suspected. Physicians were called in who reported that she seemed to suffer from some mental weakness, and the alcaide said that he could not determine whether it was weakness or malice. Calificadores were consulted, who postponed for further decision the question whether she was hallucinated, crazy or possessed. So it went on for 2 years and a half until, on September 19, 1690, it was resolved to keep her in prison, but that, before presenting the accusation, another consultation with calificadores should be had. They examined her and reported that she cried aloud and wept and ejaculated and answered no questions directly, but still asserted that carnal indulgence was embracing God, so they reserved their opinions till another time. 18 months passed away and, in March 1692, she sought an audience in which she threw herself on the ground and, with tears, begged to be taught. She knew that she ought to be content with her husband and, with screams and cries, she declared that she could not resist temptation save with the aid of God. A consulta de fe was promptly held, and another in January 1693, which could only recommend her detention in view of the evils to be apprehended if she were allowed to communicate with others. Then 2 years and a half more elapsed, with occasional reports from the alcaide and secretary to the effect that latterly the poor creature no longer talked lasciviously, in view of which it was voted, July 1, 1695, that the accusation should be presented and that calificadores should again examine her. To the report of this, the Suprema replied in vigorous language, pointing out that this was only recommencing the eternal round, and that the case promised to be immortal. It ordered that the prosecution should be promptly carried on in the usual way, and the sentence be submitted for its approbation. Here the record before us breaks off, and the final action is unknown, but it is evident that the unfortunate woman was to be treated as responsible, the hesitation of the tribunal having only resulted in her incarceration for more than 7 years in a dungeon (calabozo), where, if not insane at first, she probably became so in the darkness and despair of interminable confinement. However humane intentions might be, prejudice and ignorance misled them to cruelty. It marks a progressive improvement when, in time, it became customary, on receiving a denunciation, to interrogate the informer whether he knew if the accused was a drunkard or suffered from any mental disturbance, and, in instructions to commissioners in taking testimony, these inquiries were directed always to be made. This was a praiseworthy precaution, and the modern softening of temper produced a marked improvement in the treatment of the insane. This is well exhibited in 1818 in the case of Pedro Benito Lobarinas, in which the Suprema ordered the Santiago tribunal to treat him with special kindness and to give him every comfort compatible with his safe keeping. Confidential persons as well as the physicians are to be admitted to him, who in friendly talk could form an estimate of his mental condition, while investigations were also to be made at his place of abode. Still the outcome of the case shows the conflict between humanity and extreme dread of doctrinal error. His offence was simply some propositions and, in view of his sanity in all else and his experience as a garden labourer, he was to be handed over to the gardener of some convent so walled as to prevent his escape, and to forbid his speaking with any one, so that he might have no chance to disseminate his heresies. As for the other pleas in abatement, such as intoxication, sudden anger, thoughtlessness, ignorance, jocularity and the like, they could only be advanced in minor cases, like blasphemy and propositions not involving formal heresy. In such matters they were often alleged in extenuation and were given more or less consideration according to the temper of the tribunal, the penalties not infrequently being moderated in consequence. End of Section 8. Recording by Shena Ser, Fresno, California.